My argument to the court is that the city of Springfield does not have a variance, and that this particular pod is for religious use, and the city cannot they cannot enforce certain codes and regulations for sanitary reasons. For example, they can't say things like, well, you have to have a bathroom, you have to have a kitchen, you have to have a bedroom of 7 feet. Accommodations have to be met for other alternatives. And what is happening now is the city is saying, well, he's required to have running water, he's required to have electricity. I do have running water. It's fed through by a 12-volt electric pump. That's an alternative to the city's running water system and company that they also have, which is monopolizing the water system altogether with a privately owned man-made lake. The city is trying to capitalize on private property that is being used for religious reasons.
Okay.
And yes, I am grieving because now what's happening is the city has attempted to ask a county judge to evict me. This is technically an evictional proceeding without notice. How do I not have the proper right to have notice under state and federal law?
They'll say you got it on July 9th.
Correct, and I didn't get it on July 9th. I actually just got it last week on Friday. So
Okay, so they'll say you did get notice.
I
notice.
accepted notice, but even though the notice was unlawfully distributed, for example, the officer who provided notice taped the notice to the door. Additionally, I had told in my statement that this is a residence. They're stating that the actual location in which I live in is not a residence per city code. It is a residence per city code, and here's the reason why. I'm registered to vote at this address, and because of that, I have protections under federal law. I have services like utilities and services there. For example, Republic Services provides garbage removal on the property every Thursday. There's copies of invoices. On their invoices, it says residential. The city has to allow for alternative uses of electricity. For example, I have solar power and a generator, which most houses don't have. So I have running water, I have electricity. In terms of sanitation, I have a
Right.
private
But
bath.
they will say it's not
Yeah.
up to their city code,
Correct,
zoning
but they're-
codes, which are
but
enforceable.
It's not up to their city code because they don't have a standardization for tiny homes and tiny dwellings, specifically worship-based dwellings for those communities. So, and that is actually a civil rights violation. The city must have a variance in their city code to apply for those types of permits. And if granted, you shouldn't have to pay for those permits. There should be a fee waiver in place. They're claiming I have violated city code.
Right.
It's not a violation for an individual to build a faith-based structure, even if that structure does not meet city code. It can't meet city code currently because there's no actual variance in the code for that type of structure. So of course they're going to say it's a violation. They don't have anything that allows you for that type of use. So
I don't recall you talking a lot about the religious aspect of this, though. Is this
I
something
mentioned
that,
it
Yeah,
a
you
couple
did.
times.
You said to God, you
yeah.
had visions of God.
Yes, I said that God had
But
asked me to
are you
build
trying
this
to
park.
claim this is like a temple now, and this is a religious temple, and that's like what it is?
Well, actually, I'm not claiming that it's a temple. This is worship-based housing. So when an individual or a faith-based organization believes that their standard of living meets this criteria based on faith, they should be able to live on that standard based on that faith. So it doesn't matter if your house is made out of wood, out of brick, out of twigs. If your religion, your sincerely held belief says that, hey, God wants you to live a certain way, and this is a minimal lifestyle that I've chosen, which is to live off grid, to be separated from church and state. That is the lifestyle that I'm choosing based on my faith.
You have a fair right to do that off grid,
Correct.
but you're doing it on a city lot that's owned by the city.
So the
And
city is
So
the
what?
city does not
the question
actually
is,
own.
everybody's gonna ask you, Cole, why didn't
Yeah.
you just go out in the woods to do this?
The city doesn't. Yeah, I understand that. The city doesn't actually own the lot. They they have certain ordinances to control what happens on the lot to some degree. For example, they can set certain standards and regulations, but they don't actually own the lot. The lot is registered in Sangamon County and it's owned by me. I'm listed there on the deed.
Yeah.
So just because I'm a resident in Springfield doesn't mean that the city has full control of the lot. They can say that, you know, the grass can't be a certain height. They can say that you need to clean up your alleyway, but they cannot take possession of something that's currently being used for residential purposes and is being occupied by a resident, especially when that resident, like in my case, is registered to vote and is using it for faith-based purposes. Their argument as a plaintiff was that they said that I didn't have lights. I do have lights. They run off of battery from solar power. Their argument was that I didn't have running water. I do have running water. It is privately sourced and not coming from one direct source or through a public line like the city. So their intent is to have me build a space that is much bigger than what's needed while also burdening me as a property owner to pay for their uses and their services. In this scenario, the city has no standing in this case. There's no merit because of a couple of reasons. I don't use their public services. And as a result of that, I'm free to choose how the structure of the buildings, in this case the pod, which is protected federally, is able to be used. So unless I had connected to public services like wastewater and of course electric, can the city then say, oh, he doesn't have those, they're not turned on, and so forth. The city had actually had a water line listed at that address, but since the lot was vacant, they had removed that water line, and they are now charging $1,800 to have it reinstalled so that I could have running water. That is both unjust, unlawful, and illegal for anyone to do. So even I can argue that in court and say, well, technically it did have those things. The city chose to remove it. And as a result of that and being unable to pay for something that astronomical, I chose to have alternative ways to have running water.
Have you thought about a public defender for when you come back?
I don't believe a public defender is necessary in this case. This case is a civil rights matter. The city is using its municipal code to unlawfully interfere with one's living standard. And in this case, trying to evict someone from their own home because of their reasons. They're saying I don't have a smoke alarm. I do have a smoke alarm. I have a UPC product item number for that smoke alarm. The battery is 10 years. It allows for 10 years of use by first alert, which I have included as an exhibit of evidence in my response.